Good afternoon, guys. Aaron Dorr here with a big update for gun owners. We are still live here on the ground in East St. Louis, Illinois, in federal court as a battle to overturn Governor J.B. Pritzker's AR-15 assault weapons ban is raging hot. We're out in a lunch break right now. Wanted to cut a quick video and give you guys an update. So the government in this case, state of Illinois, clearly saved their dumbest, most arrogant, most incompetent, and probably most deviant kind of guy, if you get my drift, witness for the very end. Today's witness for Governor Pritzker is retired Lieutenant Colonel Jason Dempsey, United States Army. Jason Dempsey is here to give his personal testimony, which is that AR-15s are weapons of war, because in his 22 years in the United States Army, he never fired his weapon on full auto. And as a trainer in the United States Army, he never trained his men or women to fire their weapons on full auto. In fact, he never even trained them to fire on burst mode. In fact, Jason Dempsey believes the United States Army and military should replace all of their M4s with semi-automatic rifles only, because this idiot believes that that's a more effective fighting rifle for our military than firearms that have burst fire or full auto capabilities. These people are crazy. These people are truly demented. So Illinois spends a couple of hours laying out this guy's pedigree, all the things he's done. He's been to Afghanistan, been to Iraq. He worked for the Obama White House for quite a while. And under this pedigree, he's giving these opinions, these decisions, right? So on cross-examination, the pro-gun side gets a chance to ask him some questions. And I was taking notes in the courtroom, but I can only write so fast. I was laughing so hard, I had to control myself. I was afraid to get kicked out of the court. Because cross-examination, they ask him, they say, Mr. Dempsey, you believe that these AR-15s are weapons of war. They should not be hit in the hands of civilians. Is that correct? And they're like, that's correct. Then do you have an AR-15? And he's like, yes, I do. And they're like, do you have 30-round magazines in that firearm? Yes, I do. So completely hypocritical, as is always the case. But then it got a lot more interesting. They said, Mr. Dempsey, you're claiming that the United States military should never have their riflemen use their rifles in burst or full auto capacity. Is that correct? And he's like, yes, that's the job of the squad automatic weapon or SAW operator. The riflemen should never use their firearms in full auto. And they said, Mr. Dempsey, are you aware, because you're an expert, 22 years in the military, you're the expert for the state of Illinois, are you aware that the United States military has just adopted the XM7 as their new main rifle? And he's like, no, I did not know that. And they said, do you want to know what the fire capabilities of that rifle are? And he says, well, you're going to have to tell me. And they said, safe, semi-auto, and full auto. That's it. They've removed burst and gone straight to full auto as their final option. So you're here telling us the Army never uses, you said you never used a firearm in burst or full auto in the military, yet the entire military has moved away from the M4 to the XM7. Did you know that? And he's like, no, I had no idea. But then it got a little more personal. And I got to tell you, this was pretty incredible to watch. They said, Mr. Dempsey, 22 years in the military, you deployed in combat to Afghanistan, to Iraq, you led lots and lots of men. How many times did you fire your weapon in combat? And he said, never. And they said, okay. How many times did you join your men in kicking down a door or be on an assault element of any kind? And he's like, never. They're like, did you ever actually see active combat? And he said, not really, not much. So it's no offense to the guy for serving the military and not being in combat. That's not the point. The point is that they held this guy up like he was the be-all, end-all of military experienced personnel to give this expert opinion, when in reality is he's never been in combat, he's never fired his weapon in combat, and he's never even kicked in a door with his men in Iraq and Afghanistan. It's pretty weird stuff to hear him have to admit after all the talking he'd done for the previous hour to an hour and a half. So they really shellacked him good on cross-examination, and we're now on the redirect when we come back from lunch in about 25 minutes. We'll finish up this case, and from here what's going to happen is as follows. This is the district court level. So this Judge McGlynn, excuse me, is a Trump-appointed, pretty well pro-gun judge, and we expect to get a good opinion from this judge when this case concludes. From there, whichever side loses, state of Illinois or the pro-gun side, this case will be appealed, as is always the case, to circuit court. That's the 7th Circuit, to be honest, or to be clear, and that's in Chicago. And when that court takes this case up and gives us an anti-gun opinion, and they will, because the 7th is a very hostile court right now to gun owners, then finally we'll have a chance to appeal this case to the United States Supreme Court. That is why we are here. Now, if you're asking yourself, well, Aaron, the Supreme Court already declined to hear this case. That's true, but it's not the full context. The Supreme Court was asked to consider the preliminary injunction blocking the enforcement of this law pending the actual litigation in court. SCOTUS said, no, we don't get involved with PI motions. We don't get involved until the case has actually been heard in court, argued on its merits, and has been appealed to our court. And that's, again, where we are right now. I know it sucks. I know it takes a lot of time. I know it's a very laborious process for gun owners here in Illinois, but that's how things move in the federal court process. So a huge thank you to all of our members for all of your help. We are here in this case because the fastest way to defend gun rights in our state is to make sure we get an opinion from this Supreme Court on whether or not AR-15s are constitutional or not. Of course, we believe that they are. These rights come from God, not from the court. But this is the most pro-gun court, Supreme Court in our lifetime. And if we get Clarence Thomas and Alito and the rest of these guys to rule on this in a pro-gun way, it will reset the deck for a generation, for generations, when it comes to the fight to keep and bear arms. That is how we set up roadblocks to protect our red states, in particular, from future gun control attacks down the road, maybe 20 years from now, maybe 20 months from now, we don't know. But putting these roadblocks in place is the way we do that. Thank you to all of you for helping to fund our amicus briefs in this case, our cert petitions in this case. We're going to have more legal action in this case when it goes on the appeal phase, much more to come. But that's where things are right now here today in St. Louis. They're going to be getting back in about 20 minutes. I better get back inside. You guys have a great rest of your day.